What's up, y'all? You're watching Union Minded. I'm your host, Eric, and today I want to talk to you about a little known law that I just became aware of and I'm super excited about, called the Labor Management Reporting and Disclosure Act of 1959. It's a well-guarded secret, I suppose, even though it's not supposed to be. Or it's just something that's not very widely known. But I want to bring you the information because I think it's important that as a union member, you know this bit of information because it's out there for your protection as a union member. Now, let me tell you what it's all about. This act is meant to provide for the reporting and disclosure of certain financial transactions and administrative practices of labor organizations and employers, to prevent abuses in the administration of trusteeships by labor organizations, and to provide standards with respect to the election of officers of labor organizations, and for other purposes. Then it gives you a declaration of findings and purposes in the act, so it tells you why Congress took this action or why they felt it was necessary to create this law. So I want to briefly touch on that. This is in Section 2, Part A. It says, the Congress finds that in the public interest, it continues to be the responsibility of the federal government to protect employees' rights to organize, to choose their own representatives, to bargain collectively, and otherwise engage in concerted activities for their mutual aid or protection, that the relations between employers and labor organizations and the millions of workers that they represent have a substantial impact on the commerce of the nation, and that in order to accomplish the objective of a free flow of commerce, it's essential that labor organizations, employers, and their officials adhere to the highest standards of responsibility and ethical conduct in administering the affairs of their organizations, particularly as they affect labor management relations. So they found that it was important that not only employers, but also labor organizations had to be of the highest ethical character in order to be able to run their organizations with a responsibility and high standards in administering the affairs of their organizations, because it affects the public, right? You got Part B. The Congress further finds from recent investigations in the labor and management fields that there have been a number of instances of a breach of trust, corruption, disregard of the rights of individual employees, and other failures to observe high standards of responsibility and ethical conduct, which require further and supplementary legislation that will afford necessary protection of the rights and interests of employees and the public generally as they relate to the activities of labor organizations, employers, labor relations consultants, and their officers and representatives. So this law basically is like a set of rules for the protection of union members from their elected representation if there's ever an abuse of power, if there's ever corruption and stuff of that nature, or if there's ever anything that affects that member's life negatively that is unwarranted. You have this law that protects you. It allows for you to be able to file a suit against that labor organization to protect you from whatever unscrupulous thing occurred. I think it's very, very cool that this law is in place. Then it says for Part C on why they had to do this, the Congress therefore further finds and declares that the enactment of this act is necessary to eliminate or prevent improper practices on the part of labor organizations, employers, labor relations consultants, and their officers and representatives, which distort and defeat the policies of the Labor Management Relations Act. Then it gives you a bunch of definitions, and as you go through, you get to Title I. This part is so cool. It's the Bill of Rights of members of labor organizations. So these are the rights of union members in the federal government. It says under Section 101A1, equal rights. Every member of a labor organization shall have equal rights and privileges within such organization to nominate candidates, to vote in elections or referendums of the labor organization, to attend membership meetings, and to participate in the deliberations and voting upon the business of such meetings, subject to reasonable rules and regulations in such organizations, constitutions, and bylaws. So that says that you can't be just barred from a meeting. There has to be just cause. There's got to be a reason for it. You can't just be like, oh, I don't like the cut of his jig, and you can't go to the meeting. You do have to, pay your dues and stuff of that nature to be able to go. But they can't discriminate against anybody going to a meeting. Then you got freedom of speech and assembly. This is your second Bill of Rights, right? Freedom of speech and assembly. Every member of any labor organization shall have the right to meet and assemble freely with other members, and to express any views, arguments, or opinions, and to express at meetings of the labor organization his views upon candidates in an election of the labor organization, or upon any business properly before the meeting, subject to the organization's established and reasonable rules pertaining to the conduct of meetings, provided that nothing herein shall be construed to impair the right of a labor organization to adopt and enforce reasonable rules as to the responsibility of every member toward the organization as an institution, and to his refraining from conduct that would interfere with its performance of its legal or contractual obligations. So now what this part tells you is that you are free to voice your views at meetings. You're free to express your arguments, your opinions. You're free to speak on topics to be voted on, which we all, if you go to union meetings, you know this. But to know that there is a law out there that gives you a Bill of Rights that protects you against bad actors that may be in office that would want to bar you from a meeting or something like that, that can happen in certain places, you know what I mean? So this is cool that this exists on a federal level. That there's federal protections against the abuses of corrupt officers. Number 3, dues, initiation fees, and assessments. Except in the case of a federation or of national or international labor organizations, the rates of dues and any initiation fees payable by members of any labor organization in effect on the date of enactment of this act shall not be increased, and no general or special assessment shall be levied upon such members, except, and then this is part A, in the case of a local organization, by majority vote by secret ballot of the members in good standing, voting at a general or special membership meeting, after reasonable notice of the intention to vote upon such a question, or by majority vote of the members in good standing voting in a membership referendum conducted by secret ballot. Or B, in the case of labor organization other than a local labor organization or federal or national or international labor organization, by majority vote of the delegates voting on a regular convention. So this is saying that your dues, your initiation fees, and assessments can't be just raised without your permission. That's what this thing is saying, which again is awesome. Protection of the right to sue. This one, this one I didn't know anything about. This is news to me, but I think it's kind of cool. No labor organization shall limit the right of any member thereof to institute an action in any court or in a proceeding before any administrative agency, irrespective of whether or not the labor organization or its officers are named as defendants or respondents in such action or proceeding, or the right of any member of a labor organization to appear as a witness in any judicial, administrative, or legislative proceeding, or to petition any legislature, or to communicate with any legislator, provided that any such member may be required to exhaust reasonable hearing procedures, but not to exceed a 4-month lapse of time within such organization before instituting legal or administrative proceedings against such organizations or any officer thereof, and provided further that no interested employer or employer association shall directly or indirectly finance, encourage, or participate in, except as a party, any such action, proceeding, or appearance of petition. So this protects your right to sue for justice on a wrong that was done to you by your labor organization. They cannot stop you from pursuing legal actions. You're right. Number 5, Safeguards against improper disciplinary action. No member of any labor organization may be fined, suspended, expelled, or otherwise disciplined except for non-payment of dues by such organization or by any officer thereof, unless such member has been served with a written specific charge, given a reasonable time to prepare his defense, afforded a full and fair hearing. Any provision of the Constitution and bylaws of any labor organization which is inconsistent with the provisions of this section shall be of no force or effect. So when you read the bylaws of Local 26, for instance, you'll find a lot of the same language that you'll find in this act. Now, what I didn't know was that that language was brought about because of this act. So it's not like that language was brought about by our members who got into representative office and then decided, oh, let's be fair and let's do the right thing and let's be just and let's have equal everything. No, a federal law had to be written in order for the IBEW to change and represent this kind of stuff, which I find fascinating. I didn't know that. And then there's ways to enforce and stuff of that nature. But again, there's more to this, and I'm going to do another video on Title 4. But Title 1 right there gives you a Bill of Rights that you'll recognize. If you read the bylaws, you'll recognize some of this language in the bylaws. And now I know, and by default now you know, that it actually came from the Labor Management Reporting and Disclosure Act of '59. That's awesome. I'm going to read this some more. I'm going to get some more insight. I'm going to do some more videos about this law because I think it's important that we as union members know about federal law that protects us. Because again, there's not everybody, but there's a certain section of our membership that I know for a fact feels like they can't say anything, or they might be there might be consequences to pay for voicing an opinion. And I know that there's folks out there that feel that way. But I'm here to tell you, according to the Labor Management Reporting and Disclosure Act of '59, it's not the case. You cannot be disciplined or charged or anything like that for expressing your views or your discontent and for being vocal and being outspoken about it. That's good to know. And you know what they say, the more you know, right? Knowing is half the battle and all that other good stuff. Anyway, like I said, we'll do some more on this particular law in upcoming videos. But I wanted to give you an introduction. I know it was long and it had a lot of legalese, but look up that law. It's crazy. And remember, the fight is not left and right. It never has been. The fight is up and down, and it's going to take solidarity to win always. And I want to add to that. Each one teach one. So why don't you try to reach one? All right? Peace.